Good evening. This is Making the Case. I'm Yodit Tewolde. The federal trial for the 3 ex-officers charged in George Floyd's killing is underway in Minnesota. The focus this time shifts from what happened to what didn't. The officers J. Alexander King, Tou Thao, and Thomas Lane are all facing charges of failing to give medical aid. Thao and Kueng are also charged with failing to intervene in Chauvin's use of unreasonable force. Chauvin, now a convicted murderer, kneeled on George Floyd's neck for more than 9 minutes. Both sides delivered opening statements today, through which we learned that at least one of the defendants will be taking the stand. Here to help with the breakdown of today's events in court are my 2 legal experts, Paul Henderson, a veteran prosecutor and BNC's legal contributor, and former federal prosecutor Bianca Forde. Glad to see you 2 on tonight. Paul, some would argue that this trial of these 3 officers is more significant than Derek Chauvin's. They weren't the ones that placed their knee into Floyd's neck for over 9 minutes, but they're on trial for letting it happen. That those who witness wrongdoing and injustice and do nothing are worse than those who actually commit those injustices. So are they right?
They are right, and I would agree with that commentary. This case is more about defining what policing is and what it should be. How far does the expectation go for whom we believe law enforcement to be? And in this case, obviously this is a criminal trial, and so the standards are high in terms of the burden of proof. But this is, as we've talked about, the real issue of what are the affirmative acts that law enforcement has to take when defending, protecting both the public and people that are in custody. And that's exactly why the prosecution started off here talking about that and alluding to that responsibility, because that's the conversation. To the degree we know Chauvin is already guilty for what his affirmative actions are, the real issue now is, were there affirmative actions and duties that were created by these other officers because they were law enforcement and because they were acting in tandem with law enforcement with a collective goal and a collective objective? And now the issue is, does that collective goal and objective include discipline and murder in the case of accountability while we're in the federal courts?
Bianca, what are your thoughts on the significance of this trial and how it could change policing and that blue wall of silence regardless of the outcome here?
Absolutely, completely agreed. You just hit the nail on the head in terms of the blue wall of silence, and regardless of what the outcome is here, because of the fact that the culture of policing is ultimately what's at issue in this trial. There's a cultural overhaul that needs to happen with respect to the way policing is done in the United States. And this trial, regardless of what happens, put these officers at the forefront. This issue in and of itself inspired several states, 18, I believe, to impose failure to intervene laws so that that duty doesn't just come from federal law and the Constitution. And, there are several ways to influence conduct: the carrot and the stick, highlighting good behavior and placing a spotlight on bad behavior. This trial does the latter and has the ability to really change how policing happens in the U.S. and particularly how policing happens in poor Black and brown communities.
All right, guys, let's talk about opening statements. Samantha Treple, she's the one who delivered the government's opening, and she started with the fundamental lesson taught to all MPD officers, that in your custody is in your care, that this wasn't just a moral responsibility, but it's what the law requires under the United States Constitution. Paul, how would you grade the prosecution's opening remarks?
I would give that an A, because it makes sure that they are centered and framed on what the ultimate issue is for the whole case from the very beginning. There's no ambiguity as to what the prosecution wants to try and focus on, and that is the responsibility of these individuals that are on trial, independent of Chauvin, independent of the affirmative acting officer that's already been held accountable. And in order to get there, she's got to draw the line and the connection between the obligation of law enforcement, especially the officers that were on the scene, to point out that their inaction leads them to liability, culpability, and guilt. So I thought that was a strong presentation to present to the jury, and I'm looking forward to it. It makes sense to me why she started introducing evidence the way that she's introducing it, and looking ahead at some of what her intended witnesses are and evidence that she's going to put on in this trial.
Bianca, the prosecutor said the law required these officers to intervene and render aid, but instead they watched Mr. Floyd suffer a slow, agonizing death. Your thoughts on the prosecution's opening?
I thought that there was compelling use of language there. The slow, agonizing death, the slow motion killing, pointing out that Mr. Floyd said, "I can't breathe" at least 25 times. The duty to intervene, it's not just the right thing to do, but it's a crime if you don't do it. And she really painted a picture of conspirators, right? Former Officer Thao was no different from someone who's a lookout during a robbery. And the other two officers, in addition to Chauvin, who restrains Mr. Floyd, she really painted the picture of a concerted effort of these officers acting in unison. And the ultimate result was the death of Mr. Floyd. I thought she did a fantastic job using both language and video, because what she did was she superseded the arguments of the defense, which we heard in opening, which was, what you saw on that video that's etched into your mind, that's not what my client saw. Well, guess what? She's using the body-worn camera of the officers. So we're seeing exactly what they saw. So I thought that the language and the use of the video was very compelling.
Well, the prosecutors, they told the jury that bystanders who needed no special training, that even they knew that what they were witnessing was wrong. And some of those same bystanders that were called in Chauvin's state trial will be called to testify in this one, Paul. The prosecutor is making a clear distinction between who the professionals were that day.
They are, but what they're also doing is subtly telling the jury that those bystanders are the reasonable person. And they want them to listen. They want the jury to listen to what the bystanders were saying and come to the same conclusion as those bystanders, because that's what a reasonable person would have observed, that they would have felt that there was an obligation, that they would have felt that they should have done something other than to allow and permit something to happen, even though somebody was in custody. Because at some point, there is a shift beyond you have a suspect in your custody to, if you are there to define and preserve public safety, you also have to define and preserve public safety for people that are in your custody. And at some point, there was a shift that was recognized even by the bystanders that were there. And these officers had that same obligation. And that's what prosecution is going to show. It's not a mistake to me that they showed the body-worn camera, because the body-worn camera, as shown from a different officer, explained right away to this jury what other officers saw, what other officers experienced, and what officers knew or should have known about George Floyd and how he was being treated on that day. And so this was a strong approach, and that's why we're going to hear some of those same witnesses. Then they're going to rely pretty heavily from prosecution on what those bystander witnesses are saying in hopes of connecting their testimony to the feelings, judgment, and understanding of this jury in order to get to guilt.
Bianca, the prosecutor went through each defendant's actions that day and how close in proximity each of them were, not just to George Floyd, but to Chauvin. What's the strategy there?
Yeah, I think the strategy there is to paint this concerted effort amongst these four individuals to really work together. And they saw the actions that Chauvin was taking. They saw the distress that Mr. Floyd was under. And any reasonable person would have been able to see that what was happening was wrong. So this isn't a case where, although the prosecution has to rely to a degree to establish the duty on the training that the officers had, as you pointed out, even the bystanders, the bouquet of bystanders, of good, reasonable people who were standing on the sidelines and screaming in as advocates for Mr. Floyd, were doing more than these officers who their duty is to protect the public.
All right, so we're giving the prosecution an A, I take it, right?
They did a pretty good job.
All right, well, we're going to be moving on to the underdogs in the trial. We're going to be listening to or talking about the defense's opening statements when we come back after this short break. You're watching Making the Case. Federal prosecutors say the three former officers on trial for violating George Floyd's civil rights watched him die and chose not to act. Opening statements began today in the federal civil rights trial for J. Alexander King, Tou Thao, and Thomas Lane in Minnesota. Back with me, my panel of legal experts, BNC's legal contributor Paul Henderson and former federal prosecutor Bianca Forde. All right, guys, now to the defense. More of the most of the notable moments came from Earl Gray, the attorney who represented Kim Potter just a month ago in trial where she was convicted of manslaughter. He now represents Thomas Lane, the defendant with the least amount of experience and charges in this case. He first went into a little bit of Lane's background, mentioning how his client wanted to work with MPD like his homicide detective chief of police great-grandfather did. The prosecution objected to that. The judge sustained it, but of course, you know, the jury can't unhear it. But to the substantive parts of his remarks, he talks about Chauvin being Lane's FTO, his field training officer, and how he was told how good Chauvin was and to follow what he does. He also made sure to point out for the jury that it was Lane who asked Chauvin twice if they should move Floyd onto his side. Chauvin first responded with no, then ignored him the second time he asked. All right, so Bianca, could this argument that Lane never shied away from his responsibility to Floyd, but that Chauvin was his superior, and beyond making suggestions, what could an officer in his 6th or 7th day of training really do?
I think that Mr. Gray in that regard has painted a really high bar for former Officer Lane should he take the stand. It's clear that he made some suggestions, but it fell short of doing everything that he could possibly do. And if you look at the indictment, which excludes him from the intervene charge and charges him with respect to the deliberate indifference to medical needs, one could argue that the indictment takes into account the statements that he made to the effect he tried to influence Chauvin's conduct in any particular way. But did everything he could possibly do? I don't think that meets the standard, and that will be up to the government to establish. But what's interesting is that the jury today heard Lane's body cam. I'm sure they'll hear it again when he takes a stand, if that actually happens, and he has to now that his lawyer has promised it to the jury. But what I noted when I looked at Lane's body cam was the tone in which that he made the comments that he made with respect to, maybe he's on drugs. And I quote, he said, "I'm worried about excited delirium or whatever," right? Or delirium or whatever. So it wasn't a real urgency in his tone. It really fell short of doing everything that he could have possibly done, which was the language that Mr. Gray used. And I think the prosecution will be able to distinguish urgency from the behavior that we saw Lane display on the body worn camera footage.
Well, Paul King, the other less seasoned officer, his attorney, Thomas Plunkett, in his opening pointed to the fact that FTOs had great control over a young officer's future in the department, that an officer can actually be terminated on an FTO's recommendation. So your thoughts on that point, that what could a less seasoned officer really say to a superior?
Well, I think you've uncovered part of what we're going to be focused on in this trial is both advocates trying to explain to the jury and to the rest of the audience what it means to be a superior officer and what the obligation is to follow those rules. Keep in mind, though, that the boundaries of those rules is the obligation to perform your job, which is to define, to protect, and to serve. And in this case, they did not protect and serve George Floyd. And at some point, it doesn't matter that he's a suspect. He is a human, and you are obligated as law enforcement to help him. I don't think it's a mistake at all that they have Lane, and they're fleshing out Lane, his background, and his persona the most, and you'll hear most about him as a representative for the other two that are on trial. And it's not lost on me, because I do think, and we haven't brought this issue up yet, but this again is another interpretation of race. Whether we're being direct about it or not, we have to talk about race and disproportionately how much race affects how law enforcement may affect, both in this case and in other cases. So I don't think it's a subtle thing. I don't think it's a mistake that they're using Lane to speak on behalf of the rest of the officers in this context, even though he is not charged as much as the other two are charged. So he's not charged with the failure to stop Chauvin, but he will be giving testimony about that specifically. One of the things that I think that I'm going to be looking for in this case is to hear more definition about what that expectation is, both from officers inside the force and from the advocates arguing this, beyond just the focus of trying to get these defendants off because there was no specific intent. And they've already indicated that that's where they're going in this case, that they want to try and focus on that to try and absolve them of liability, to talk about the intent and make a whole series of other defenses that I think we're about to get to coming forward in this trial.
Bianca, the defense made some of the same arguments that were made in Derek Chauvin's state trial, talking about the drugs in Floyd's system. You mentioned the excited delirium theory. Again, painting Floyd as superhuman, all of which clearly didn't work. Why wouldn't these attorneys steer clear of what didn't work and go with a different strategy?
That's a good question. And, I thought that Attorney Gray was probably the biggest perpetrator in that regard. And it's unfortunate, but that theory is something that you see in criminal courtrooms all over the country when we demonize the community that these police officers enter. And that's in part, a large part of why we see so many of these unarmed killings of Black and brown and poor people, because these officers go into these communities with this heightened fear, this militarized view, this mindset of war. And when an attorney like Mr. Gray uses such inflammatory language that really just sort of exacerbates that mentality, it really is disappointing. It really is disappointing. So why wouldn't he stay clear of that strategy? I'm not sure. We saw him do the same thing in Kim Potter's trial. It didn't surprise me that he took that approach in this trial.
Paul, the attorney for Tou Thao, he tried to hit on similar themes, arguing Floyd refused to follow commands and was acting erratic. He also argued that the video that clearly the world had watched in horror doesn't necessarily tell the whole story, that none of the bystanders watching from the sidewalk didn't have the full context of what was really going on. So given how inexperienced these officers were in comparison to their superior, Derek Chauvin, could this jury buy this argument this time around?
I'm hoping they don't, but what he was arguing there is he's planting the seed for what he's going to argue later on, and this is going to be one of the defenses. And just so we're clear, and we're talking about this, and we've just shifted from talking about the approach from the attorney Gray that was going to blame George Floyd, and we've already heard that. I think we'll hear more of that as the trial unfolds, specifically from Gray, and then he'll leave the other defenses to the other lawyers to be arguing, because they're arguing collectively. I think the cumulative effect of their arguments are going to focus on three separate lanes. One, to blame Chauvin for being responsible for all of it, and that's going to have a subcategory of he was a superior officer that they couldn't overrule or overturn, even though someone had, and they were deferential to his attempt, and that's why they didn't do it, so they shouldn't be held to blame. Two, they're going to blame this as a training failure, to say that this is how they were trained. They didn't know any better. This is what they learned at the academy, that they had to stand down, that they had to let it unfold, that they didn't know what to do. I'm opposed to that argument, but I believe that that's going to be the main argument. And that's why they're starting to talk about and bring up the issue of they haven't been on the force for very long, that they had to listen to a superior officer because they hadn't been in a situation. And obviously, the third lane of accountability that they're going to try to use in their defense is to blame George Floyd. Each one of those is a different disappointment, and I'm hoping that this jury won't be tricked into following one of those lanes to not hold these officers accountable.